Swayam Prabha. Digital India. Educated India.
Hello students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU, and this is my 40th lecture to which I am going to present before you. And this is International Norms and Protection of Rights of Child in India. So I would like to highlight, this is typological error, International Norms and Protection of Rights of Child in India. So in this context, I have referred few important international instruments. The first international instrument is International Convention on Rights of Child 1989. This is most important international instrument on the rights of child. In brief, it is referred as Convention on Rights of Child 1989. So I would like to discuss salient feature of this CRC. Right of child under Indian legal framework. So I will discuss this rights of child under Indian legal framework separately. First of all, I would like to discuss International Convention on Rights of Child CRC in detail. So the first important thing which you can see on your screen, that is right to life, right to equality, right to education up to 18 years, right to health. So now let us understand that how CRC has contributed a lot in protection of rights of child, how CRC has contributed a lot for the betterment of children globally, across the globe. So you see, the first effort which was made by General Assembly in 1989 was to recognize certain rights of children across the globe. So the first important thing is that General Assembly, with the help of member states, reached a conclusion that, and all member states, they expressed their collective view, their collective vision in that resolution, that all the member states shall provide education free of cost to children of their respective states. The problem is that India too is a party of this CRC, and according to that Convention on Rights of Child 1989, the definition of child is a person who is below 18 years shall be treated as a child. Contrary to this, our constitution says that no person below the age of, no child below the age of 14 years shall be employed in any hazardous establishment. Article 24 gives definition of a child, that is a child who is below 14 years. On the other hand, this international instrument talks about that a child who is below 18 years. So there is a 4 years difference between the age of child. So you see this, what the point which I wanted to justify, that at international level, by this instrument, all the member states have agreed that they shall provide education benefits to their children up to the age of 18 years. But Constitution Supreme of the land talks about, gives liberty to a child who is below 14 years. So now come to this, what are important rights under this CRC. All the children shall have right to live with human dignity. All the children are equal in eye of law, irrespective of caste, creed and religion. All the children are equal. Children have right to education. They are entitled to get free education free of cost up to the age of 18 years. Right to health. All member states shall make endeavor to provide nutritious food to their children, and for that purpose, without providing nutritious food and without maintaining their nutrition level of the children, we cannot create a good world for children. So all the member states have given their consent to provide good health to their children. So this is some important rights provided in CRC. Now come to CRC 1989 and rights of child. As I said, child, according to this CRC, a person who is below 18 years is considered as a child. They are equal. You can see on your screen, they all are equal. Right to free education up to age of 18 years. CRC is very clear on this. State parties shall ensure their children good health and nutrition level. So all the state parties shall ensure their children good health and nutrition level. So CRC is very clear on this, providing nutritious food and education free of cost. Now come to right of child under Indian legal framework. So let us understand that what are the rights available to children in India. The first thing is that I have mentioned some important rights on your screen. You can see on your screen, right to equality, Article 14, right to life, Article 21, right to education, Article 21A, right to health, Article 21, right against exploitation, Article 23 and 24. So these rights are provided in the Constitution of India. So I will try to explain you the rights available to children under the Constitution and under the statute. So what are those various statutes which Parliament has enacted for the betterment of Indian children? I will discuss even that aspect. Here I would like to explain those important rights which are provided by the Constitution to the children for their development. So the first important right which I would like to mention, that is right to equality. Article 14 of the Indian Constitution says that state shall not deny to any person equality before law or equal protection of law within territory of India, meaning thereby all persons are equal in eye of law and equal protection shall be given to all the persons. Person here includes children also. Person includes male as well as female. Person includes child, old age people. So that is why our constitution makers deliberately put person under Article 14 of the Indian Constitution. So you need to remember this thing. So all the persons shall have right to be treated equally, and states shall not deny to any person equality before law or equal protection of law within territory of India. So all the children are equal in eye of law. States shall not make any discrimination on the ground of race, caste, section. On the other hand, Article 15 Clause 3, Article 15, I am just referring Article 15. Article 15 of the Indian Constitution says that no discrimination shall be made by state on the ground of race, caste, sex and religion. This is specifically mentioned in Article 15 Clause 1 of the Indian Constitution. On the other hand, Hello students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU, and this is my 40th lecture to which I am going to present before you. And this is International Norms and Protection of Rights of Child in India. I would like to highlight, this is typological error. international norms and protection of rights of child in India. So in this context, I have referred few important international instruments. The first international instrument is International Convention on Rights of Child 1989. This is most important international instrument on the rights of child. In brief, it is referred as Convention on Rights of Child 1989. So I would like to discuss salient feature of this CRC, right of child under Indian legal framework. So I will discuss this rights of child under Indian legal framework separately. First of all, I would like to discuss International Convention on Rights of Child CRC in detail. So the first important thing which you can see on your screen, that is right to life, right to equality, right to education up to 18 years, right to health. So now let us understand that how CRC has contributed a lot in protection of rights of child, how CRC has contributed a lot for the betterment of children globally, across the globe. So you see, the first effort which was made by General Assembly in 1989 was to certain rights of children across the globe. So the first important thing is that General Assembly, with the help of member states, reached a conclusion that expressed their collective view, their collective vision in that resolution, that all the member states shall provide education free of cost to children of their respective states. The problem is that India too is a party of this CRC, and according to that Convention on Rights of Child 1989, the definition of child is a person who is below 18 years shall be treated as a child. Contrary to this, our constitution says that no person below the age of, no child below the age of 14 years shall be employed in any hazardous establishment. Article 24 gives definition of a child, that is a child who is below 14 years. On the other hand, this international instrument talks about that a child who is below 18 years. So there is 4 years difference between the age of child. So you see this, what the point which I wanted to justify, that at international level, this instrument, by this instrument, all the member states have agreed that they shall provide education benefits to their children up to the age of 18 years. But Constitution Supreme of the land talks about, gives liberty to a child who is below 14 years. So now come to this, what are important rights under this CRC. All the children shall have right to live with human dignity. All the children are equal in eye of law, irrespective of caste, creed and religion. All the children are equal. Children have right to education. They are entitled to get free education free of cost up to the age of 18 years. Right to health. All member states shall make endeavor to provide nutritious food to their children, and for that purpose, without providing nutritious food and without maintaining their nutrition level of the children, we cannot create a good world for children. So all the member states have given their consent to provide good health to their children. So this is some important rights provided in CRC. Now come to CRC 1989 and rights of child. As I said, child, according to this CRC, a person who is below 18 years is considered as a child. They are equal. You can see on your screen they all are equal. Right to free education up to age of 18 years, very clear on this. Their children good health and nutrition level. So all the state parties shall ensure their children good health and nutrition level. So CRC is very clear on this, providing nutritious food. And now come to right of child under Indian legal framework. So let us understand that what are the rights available to children in India. The first thing is that I have mentioned some important rights on your screen. You can see on your screen. Right to equality, Article 14. Right to life, Article 21. Right to education, Article 21A. Right to health, Article 21. Right against exploitation, Article 23 and 24. So these rights are provided in the Constitution of India. So I will try to explain you the rights available to children under the Constitution and under the statute. So what are those various statutes which Parliament has enacted for the betterment of Indian children? I will discuss even that which are provided by the Constitution to the children for their development. So the first important right which I would like, that is right to equality. Article 14 of the Indian Constitution says that state shall not deny to any person equality before law or equal protection of law within territory of India, meaning thereby all persons are equal in eye of law and equal protection shall be given to all the persons. Person here includes children also, male as well as female. Person includes child, old age people. So that is why our constitution makers deliberately put person under Article 14 of the Indian Constitution. So you need to remember this thing. So all the persons shall have right to be treated equally, and states shall not deny to any person equality before law or equal protection of law within territory of India. So all the children are equal in eye of law. States shall not make any discrimination on the ground of race, caste, section. On the other hand, Article 15 Clause 3, Article 15, I am just referring Article 15. Article 15 of the Indian Constitution says that no discrimination shall be made by state on the ground of race, caste, sex and religion. This is specifically mentioned in Article 15 Clause 1 of the Constitution. On the other hand, Article Clause 3 says that nothing in this article shall prevent the state from making any special provision for children and women, meaning thereby state is free to make any special legislation for children and women. So neither that law can be challenged on the ground of sex discrimination, that Parliament has enacted a special legislation for the benefit of women, and that is the gender discrimination, that is the discrimination made by the Parliament on the ground of sex. No, that thing cannot be challenged before the Supreme Court, because Constitution itself gives liberty to the Parliament to make a special legislation for the betterment of children and women, and there is no doubt at all that Parliament has power to make a special legislation for the children. And in the light of that provision, in the light of Article 15 Clause 3, Parliament has enacted a special legislation for the betterment of children. In order to abolish child labor from this country, Parliament enacted the Act 1986. So this act was enacted by the Parliament in order to abolish child labor problem from this country. The Child Right Commission Act 2006. So by that act, Parliament made a good effort to set up a commission at national level and state level. National Commission for Children, State Commission for Children. So you see, Parliament, by enacting that special legislation for the protection of rights of child across the country, there shall be two commission. One would be at national level and another would be at state level. So state commission will have certain obligation. I will discuss in coming hours. So here I would like to highlight Article 14, Article 21, that is very precious rights, right to life. Article 21 of the Indian Constitution gives liberty to all human beings to live with human dignity. Children too are entitled to live with dignity because they also come within ambit of person. Person word has been used under Article 21. I just want to, why I am emphasizing Article 21 of the Indian Constitution. Children too are entitled to live with human dignity, and whatever things are required for a dignified life, children are also entitled to get all the benefits from the state to live dignified life. This is Article 20. Come to right to education. Why education is necessary? You see, this right to primary education was considered as fundamental right, though not directly but indirectly. Supreme Court in Mohini Jain case and Uni Krishnan case, Supreme Court held that right to education is a fundamental right, that is essential component of Article 21 of the Indian Constitution. In order to provide education, primary education free of cost, Parliament for the first time enacted special legislation. I would like to mention that legislation on your screen so that you can understand what is the law on this point. That is the right to education. I am just mentioning that the right to education act, right to education, in short, you can, in brief, you can refer it RT 2009, Right to Education Act 2009. So Parliament has enacted that special legislation for whom? Especially for the children of this country, so that we can educate them. And liabilities lies on state to provide education free of cost. Without recognizing right to education as a fundamental right, we cannot enhance our literacy rate and we cannot create a good world for coming generation. So with these objectives, Parliament has enacted the Right to Education Act 2009. By that statute, compulsory education for all, you might be knowing that there was a slogan, education for all. United Nations General Assembly few years back decided to educate all the people across the globe, adult education, child education. So United Nations General Assembly started a campaign across the globe in order to educate elderly people as well as children, education for all. Even that policy was also adopted by Government of India as a adult education, so that we can educate our literacy rate, we can educate our elderly people who are not literate, who are illiterate. So to educate them, Government of India also adopted that adult education policy. Here this act was enacted by Parliament just to provide benefit to the children of this country, so that children, they can also get, poor, particularly poor children, they get on the cost of the government. So by this enactment, governments have been directed to provide free education to their children up to the age of 14 years. So from 6 to 14 years, it is specifically provided that every child who is above 6 and below 14 years shall have right to get primary education free of cost, not from the private school but from the government school. Private schools, they so this is right to primary education. Now come to right to health. How this right would be recognized? Without giving without maintaining nutrition level, without providing conflict with law, is a child who has breached the law. Let me repeat, juvenile in conflict with law is a person who is a child who has breached the law. So that child in conflict with law, means who has breached the law, shall be kept in observation home. There is a provision of observation home to keep juvenile separately, so that they cannot be kept in the juveniles, they are not kept in jail, prison. The purpose behind not putting them in jail is to avoid juveniles, to prevent juveniles from becoming hardcore criminals. If they would have been, suppose if they would have been kept, if they are kept along with hardcore criminals, there may be possibility that they may also become hardcore criminal when they are kept in. So that is why juvenile globally as well as in India, juveniles, they are kept separately. There is separate provision for them. They are kept in observation home and there is special treatment for them. This is the one aspect of juvenile who is in conflict with law. Another aspect is a child who is orphan, who has lost his parents. That child has no parents, neither father or mother, or missing child, abandoned child, children who are found on railway platform or bus stand anywhere. So those missing children or those abandoned children, they are also kept in shelter home. So each and every district has its own shelter home, observation and shelter home. So why they are kept in shelter home? What is the use? Why government will have to put them in shelter home? The philosophy behind putting them in shelter home is that India is a welfare state. In welfare state, the ultimate responsibility lies in the state. State has to protect life and limb of a citizen. Where life or limb of a citizen is endangered, threatened, it is believed that that state has failed to protect life and limb of a citizen. So that is why ultimately state has to pay compensation to the victim of crime, where state has failed to protect life and limb of its citizen. Where offender cannot be traced, offender cannot be identified, and crime has been committed. So question will arise that when offender is not identified, when offender is not traced, then why government will pay compensation to the victim of crime? Question may arise. You may have doubt when no one has seen that who has committed that crime, who has killed someone, murderer is not identified, bank robber is not identified, then why state will provide compensation to the victim of crime? The reason is state ultimately state is responsible to protect life and limb of its citizen. Meaning thereby, where this kind of crime is committed, offender is not identified, is not traced, and crime has been committed, someone has got injury or someone has been killed, it means state has failed to protect life of its citizen. So because of that presumption, ultimately state will have to provide compensation, financial assistance to the victim of crime. State will have to take care of that victim of crime. So with these ideas, state will have to provide protection to that missing child, to that abandoned child, to that orphan child, and state will provide all the basic requirements to that missing child or abandoned child. So for that reason, each and every district has shelter home as well as observation home. But unfortunately, it is seen that the boundary of observation home and shelter home is same. In one part of that campus, children who have breached the law, children in conflict with law, they are kept, and in another part, children who are missing or abandoned children are kept. But when I have seen such kind of things, I have visited few places. I have visited district observation home, district shelter home, where I found that only a single boundary make a division between those children who have committed crime and those children who have lost their father, missing children, abandoned children. So if suppose they are allowed to play together, if they will play together, obviously those children who are orphan, missing children, they will come into the contact of those children who have committed crime. There is possibility, there is chances that the child who is missing, who is orphan, may also become criminal, may also in coming with that children who has committed the crime. So I have seen such few places where I found this irregularity, and I also draw attention of the administration that we should make such effort so that they can keep separately, otherwise problem may arise. This is the practical problem which juvenile who is in conflict with law and children who has done nothing, but they are unfortunate because they have lost their parents, they are abandoned, and they are kept in the same premises. Premises is same, boundary is different. In one part, children who has committed crime, they are kept, and in another part, children who are orphan or missing children, abandoned children are kept. So this is one important thing which needs to be addressed. Second important thing is that juvenile has to be produced before the trial court. If trial court has convicted him, ultimately if trial is concluded and trial court found them guilty, in that case what will be done? Then the provision is that in section 360 of the CRPC talks about probation and admonition. So section 360 of the Code of Criminal Procedure 1973 provides that where offence has been committed by a child who is below 21 years old and has not committed any murder, then that child, instead of convicting him, instead of awarding sentence to him, that child should be released on probation. That child should be released after admonition. That child should be released on probation for rehabilitation purposes, so that he can be rehabilitated. The purpose behind releasing that child on probation is to keep him under judicial supervision. If his conduct is good, and the maximum period of probation is 3 years, if his conduct is good, he is observing that child who is on probation is observing good life, he does not commit crime again, then he must be released on probation, and so that he can prevent himself. So the philosophy behind probation is that just to give an opportunity to the accused so that accused can repent himself. many times it is seen that due to hot talk or all of a sudden person commits crime, and after few hours or few minutes they repent themselves that they have committed wrong. That act should not be committed, should not have been committed by them. So just to rehabilitate them and just to give one chance so that they can repent themselves, that they had, if they are accepting their guilt, that they did wrong, and with that idea, with that philosophy, the concept of probation was incorporated in the Code of Criminal Procedure 1973. That is very good step, because that is a process of rehabilitation. You might be knowing that there are 4 important theories of punishment: reformative theory of punishment, deterrent theory of punishment, retributive theory of punishment. So reformative theory of punishment is one important theory of punishment which is in favor of releasing more and more criminals so that they should be given a chance to live amicably, to live peacefully in society. If they do not create problem again, why not they should be given a chance to repent themselves? So because of that perception, reformative theory of punishment is in favor of giving leniency to the offenders. Reformative theory of punishment is in favor of releasing juveniles so that they can repent themselves and they can be rehabilitated, they can be brought into the mainstream of the society. So this is the purpose of probation, behind giving probation to the accused. So juvenile can also be released on probation, and this is all about your juvenile. The Juvenile Justice Care and Protection of Children Act 2015. Juvenile Justice Board is there. Juvenile Justice Board has to take appropriate decision for the betterment of juveniles. So with this, I would like to move on next slide. Now let us understand the role of Supreme Court in protection of child rights. So we will try to understand that how far Supreme Court has been effective in protection of rights of child. So with the help of judicial pronouncement, I have referred 3 important case laws. You see, Munna versus State of UP, that is known as Kanpur jail case. Second is Badhua Mukti Morcha versus Union of India. Third case is Saheli, a women resource center versus Delhi Police Commissioner case. In this case, compensation in case of custodial death was awarded, and judicial safeguards to the rights of child. So you see, I have chosen 3 important, though there are so many cases wherein Supreme Court has intervened for the betterment of Indian children. I have chosen these 3. Munna versus State of UP. This is a leading case on violence against children. Violence against children is a big threat in protection of human rights. So in this case, the plight of children who were kept in Kanpur jail was highlighted, was brought into notice of Supreme Court, and after the inquiry, Supreme Court found all allegations true, and state concerned were directed to take effective measures so that the rights of children, so that sexual abuse against children could not be committed. Second case, I just want to discuss all these cases in brief because due to time constraint. Badhua Mukti Morcha is another important case where I have just highlighted the facts of this case in my previous lecture. Badhua Mukti Morcha case filed a petition before Supreme Court by highlighting the plight of workers who were working in Faridabad district, Haryana, and were engaged in stone quarries. Supreme Court took cognizance. Government is concerned were directed to release all the bonded labor from that place, and Supreme Court also issued directions for all the chief secretaries of the states and union territories to implement those guidelines for the rehabilitation of bonded labor. Every chief secretary will have to ensure that there should not be any case of bonded labor in their respective states. Shaheli is another third important case where a 9-year-old child was found dead in police lockup. Since the mother of deceased child was not in position to fight her case due to poverty, so this non-governmental organization, this NGO, decided to fight her case on behalf of the deceased mother, and matter was brought into the notice of Supreme Court. Supreme Court issued direction against the government concerned, and also Supreme Court held that it is a case of custodial death and all the police personnel who were involved in that incident must be punished, must be prosecuted and punished. Compensation must be awarded to the mother of deceased, and she was awarded compensation. Compensation may be adequate or inadequate, it may be matter of debate, but ultimately Supreme Court issued direction so that compensation can be provided to the mother of deceased. Now with this, I would like to move on second slide. This is judicial safeguards to rights of child. I have mentioned the 3 cases, so I think I have referred 6 cases, 3 on that slide and 3 cases on this. PUDR versus Union of India, AIR 1986 Supreme Court. This case is also known as a SIAT case. Child labor issue. You can see on your screen, then after I will discuss this case one by one. Sheila Barse versus Union of India, AIR 1986. And third is right to education is a fundamental right, MC Mehta versus State of Tamil Nadu. State of Tamil Nadu, this one. Now this, let us discuss all these cases one by one. What happened in this PUDR case? PUDR, People's Union for Democratic Right. This is an NGO, and as I said, I would like to quickly highlight the facts of this case that paid till date. So considering the gravity of matter, Supreme Court held that it is violation of fundamental right where workers are not paid by the contractor, and government was directed to ensure that those workers who were engaged during Asian Games must be paid their dues, and accordingly government had to pay remuneration, wages to the workers engaged during Asian Games. Sheila Barse versus Union of India is another important case. You all might be knowing that she had conducted a survey in the state of Maharashtra, and she found that in different district jail, many children, they had been kept along with hardcore criminals. Contrary to this, they should have been kept separately. But when survey was conducted by Sheila Barse, and she was a social activist, so she found that many children had been kept in prison along with hardcore criminals, and there was no separate provision for them. So petition was filed in Supreme Court. Meanwhile, Supreme Court constituted an inquiry committee to find out the allegations made by that Sheila Barse, and Supreme Court Legal Aid Committee also filed a petition in Supreme Court that something is going wrong with the children of this country. And meanwhile, I'm just trying to throw some light, and meanwhile Sheila Barse, she decided to withdraw her petition. When she expressed her view before the Supreme Court, she was not allowed to withdraw her case, and ultimately There is also leading case, Supreme Court Legal Aid Committee versus Union of India. When Supreme Court asked the Government of India whether Government of India is having any special legislation where there is separate provision for juveniles, so Government of India did not give satisfactory answer to the Supreme Court. So Supreme Court directed that juveniles who have been kept along with hardcore criminals in prison must be released immediately, and government, all the state governments were directed, Chief Secretary were directed to provide action taken report within a specified time to the Supreme Court, what action they have taken in this regard. So this you can understand how Supreme Court took cognizance in this case. Now third important case is MC Mehta vs State of Tamil Nadu. This is leading case on child labor, which I have already highlighted in my previous lecture, that because of this man many child labor issues have been addressed in this country, and MC Mehta highlighted the plight of children who had been engaged in construction of matchstick in Sivkasi district. So Supreme Court took cognizance and directed the state government to release all the child labor from the place, and employer must be compelled to provide financial assistance to those children who had been engaged in their matchstick manufacturing establishment. Supreme Court directed the employer that employer should have provide 20,000 rupees for their education, 25,000 rupees till they attain the age of 14 years. All the things, all the well-beings should be taken care of by the employer. Employer should provide financial assistance to the children. So Supreme Court intervened in this case. This is now, with this I would like to move on next slide. This is Protection of Children from Sexual Offence Act 2012. This is known as POCSO, Protection of Children from Sexual Offences Act 2012. I would like to discuss this case briefly. The nature of offence where any child who is sexually abused, after the commencement of this act, where any child who is sexually abused, the nature of that offence is cognizable and non-bailable. The moment complaint is filed regarding child sexual abuse, at that very moment it gives liberty to the police officer to arrest the offender without order of the court. Nature of offence is very serious, cognizable, non-bailable, and once complaint is filed regarding POCSO, in this act court will not release the offender unless investigation is completed by the investigating officer, and by that investigation, by that charge sheet, if police officer found not guilty to the accused, only then he will be allowed bail, or he can be released on bail. But that law is very tough, law is very serious in nature. So three things are very important. You must remember the nature of this offence is cognizable, non-bailable offence, and this violence against children, as I said, is a big threat in protection of human rights. So that is why this act was enacted by the Parliament. Apart from this, I would like to mention two important things. Just I want to write on this. Dolly Capex. You all might be knowing that Dolly Capex, section 82 IPC, though IPC has been repealed, and Dolly in Capex, that is section 83 IPC. It is specifically provided in section 82 of the Indian Penal Code that a child who is below 7 years cannot commit any crime. I am referring section 82 of the Indian Penal Code. Nothing is an offence which is committed by a child who is below 7 years. So the concept of doli in capex has been recognized under section 82 of the Indian Penal Code. Doli in capex here means, doli means a child, in capex here means incapability. So incompetence or incapability of a child. It is believed that, you see why a child who is below 7 years cannot be prosecuted and convicted. Section 82 says that nothing is an offence which is committed by a child who is below 7 years. So a child who is below 7 years is not in position to understand the nature and consequences of his act. So that is why, because of immaturity, he is not in position to understand the nature and consequences of his act. So that is why he cannot be held liable for his act. So on the other hand, section 82 of the Indian Penal Code, 83 of the Indian Penal Code talks about doli capex. Doli means child, and in doli capex, doli means a child and capex means capability. According to section 83, a child is considered as a competent, a child is considered to have acquired competence, sufficient maturity to understand the nature and consequences of his act if he is in position to understand the nature and consequences of his act at the time of the manner in which he has committed crime, his subsequent conduct, his previous conduct can be taken into consideration by the court while deciding his guilt. So a child who is above 7 and below 12 can be held guilty, can be held responsible for the crime. So this is limited immunity given to a child, but absolute immunity is given to a child who is below 7 years. He cannot be prosecuted for any act. So this is, you see, we have also adopted this concept in our legal system, and apart from this, I think I have discussed each and every aspect of rights of child. I started my discussion from constitutional provision, Article 14, 15, 21. I also highlighted Article 21, Right to Primary Education, 86th Amendment, Right to Education Act, Article 23, 24. What constitutional safeguards have been provided to Indian children? Firstly, I highlighted constitutional provisions. Then after, I highlighted statutory provisions related to the welfare of Indian children. So in that context, Child Labour Prohibition Act, I referred Child Labour Prohibition Act, the Protection of Human Rights Act 1993, National Commission for Children Act 2005, and then after I discussed Right to Education Act, Prevention of Protection of Children from Sexual Offence Act 2012. So I have discussed all the relevant statutes pertaining to the rights of child. Then after, I discussed the role of Supreme Court, how Supreme Court has played significant role in protection of rights of child. I have discussed, I have highlighted certain case laws so that you can understand, you can get entire information regarding rights of child. For example, I discussed Munna vs. State of UP, MC Mehta vs. State of Tamil Nadu, Badua Mukti Morcha vs. Union of India case. I also discussed Sheela Barse case, Sheela Barse vs. Union of India. So, role of Supreme Court in protection of rights of child. And then I discussed this other constitutional safeguards provided to the children. So with the help of this slide and with the help of judicial pronouncement, I tried to reach your mind, and I do believe that if you all have remember all these things, I have also referred PUDR case, ACR case, Delhi Police Commissioner, and Juvenile Justice Care and Protection Act. I have also highlighted the salient feature of Juvenile Justice Care and Protection of Children Act 2015, role of Juvenile Justice Board, difference between juvenile conflict with law and children who is in need and care of protection. I also discussed that aspect. So I think I also discussed international instrument convention on rights of child. So this is an important international instrument through which I explain the international aspect of international view on this right international instrument. So I think I have covered each and every aspect pertaining to rights of child globally as well as Indian perspective, legislations and role of Supreme Court with regard to protection of rights of child. So I do believe that you all have understood the things which I have just discussed in this lecture. Assuming that if you have memorized all these things, you can get success in any examination related to this paper, but rights of child. And with this, I would like to conclude this lecture. Thank you all.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that's the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally you try to combine all of them to say that what are the guiding principles in life then you say you are looking at life, you are looking at humanity from a pure philosophical point of view. And this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.